Having trouble again?
Yeah, it's just a little hiccup every time. It's moving now. There it is. We're on.
Okay, welcome back, everybody, to Senate Economic Development, Housing and General Affairs. We're pivoting to housing again, even though it's, well, it's sort of when people were available. So we're pivoting to housing on a Labor Day, but there we are, because we need to finish up and get this to the House. We are going to revisit the municipal appeals section. The municipal appeals are in our jurisdiction, and Act 250 appeals, as we know, are in SNRE. And so the House gave us a proposal to streamline who's able to appeal municipal decisions. And so today we are going to look at the work that Ellen has done with some of the other stakeholders to revisit the language. Some of them felt the language that we saw was perfectly fine and didn't need to be played around with, but we've tweaked it a little bit because we felt that some things needed clarity, in particular, identifying particularized interest and some other things. So Ellen, if you'd be kind enough to tell us what you did and what our options are, and then we're going to hear from a couple of the stakeholders.
Ellen Tchaikovsky, Office of Legislative Counsel. So today I have for you draft 1.1, which is an excerpt proposal amending the housing appeals related section that I have worked on. So it's draft 1.1, dated with yesterday's date. And so there are a couple of pieces that are clarifications of what was already in here. So you will recall that the House's proposal is to change the standing requirement for who can appeal municipal permit decisions. Currently under the statute, there are 5 prongs of the definition of interested person who are allowed to appeal municipal permit. This is a different set of standards than who is allowed to appeal Act 250 permits and A&R permits. And so what the House is proposing is to use the standard that's used for Act 250 and A&R permits, which is the person aggrieved standard. And so that language is on page 1 in section 8. So a person aggrieved is a person who alleges an injury to a particularized interest protected by the provisions of law listed in 8503. It adds the reference to appropriate municipal panel, which is who makes a decision on municipal permit decisions. And so that's what the House sent. But as we discussed last week, I was slightly concerned that it's vague about what the interests are that are protected under Chapter 117. And I think that can be open to debate, and perhaps others don't share that concern. But Senator Clarkson also had that concern. And so I'm proposing here as a way to narrow that by referencing for purposes of appeals pursuant to Chapter 117, the injury alleged shall be to a particularized interest protected by 24 VSA 4302C. So I also had Heidi post today, section 4302. So it's on your website under my name, and it's just a PDF of what is in the statute. So 4302 is the first statute under Chapter 117, and it's 6 pages long. It's quite a long statute, but it lists the goals and purposes of Chapter 117. And so Section C is an enumerated list of 15 different items, which are the chapter shall be used to further the following specific goals. And so it's a number of goals. I don't know if we have time to walk through them, but we could. And there are actually a couple other sections in 4302. So perhaps even just adding just a reference to the whole section, because there's other language in the rest of 4302. But because 4302 is an enumerated list of the goals of the chapter, I thought that would be something more specific than just referencing interests protected under the whole chapter.
And that did need clarity. So I think that adds clarity and reference is something that that, fully illustrated, all 6 pages of it, fully illustrates particularized interest.
Okay.
Okay.
So, yeah, and I think you could make other choices, like you could be less specific, or you could pick section A as overall the general purposes of the chapter. So you do have options, just something for you to consider.
Why don't you do the whole thing, and then if we want to see that whole enumerated list, we could.
Okay.
Because we're hanging a lot on agreed person.
Yeah. I think potentially if you don't include this reference, basically what would happen is that the court would just evaluate when someone makes an argument that I've been aggrieved, they would look at whether or not what their injury is something that is protected by Chapter 117. And so the court has the ability to make that determination. They would review it. But I think this is providing a little more, example for the public who are looking.
Absolutely, and also then directs the court to what we were looking at, that for fully illustrates agreed persons.
Yeah. The next small change on this page 1, I did add the cross-reference for the definition of appropriate municipal panel, because that definition is in Chapter 117, and this is Chapter 220 of Title 10, so just adding a cross-reference to make sure it's clear. The next change is on, it would have been on page 2, but on page 2, I'm sorry, I didn't provide highlighting. I was working on this. On page 2, what would have been under de novo hearing, in what the House sent was that language about the court would look at if the permit was consistent or inconsistent with the bylaw. I think you heard from Judge Zone that is what they already do, and so it's unnecessary to include it because it's redundant. And so that language has been removed here.
And then you added in one, the person agreed in the appropriate municipal panel.
Yep, I added it.
Consistency.
Yes, I added the reference to the appropriate municipal panel, just for consistency, especially since the phrase was being added.
Okay.
So the other main change in this document is the discussion that came up about interested person. So in section 10, it did come up in testimony that the list of interested persons, the 5 different types,
Do you want to just sort of mention what's at the bottom of the page? The addition number 5.
Sure. So that hasn't changed at all. So the language at the bottom of page 3 is what the House sent you, and this is asking the court to prioritize the cases involving housing development.
Why are you making this indicate that it's new language if it came from the House?
Because it came from the House. It's
not
new to you.
It's over.
It's new to
It's
the
new in
statute.
statute.
The House is proposing to
Okay.
add the language at the bottom of page 5.
Right.
Yep.
Okay, so to section 10.
Yes. So in section 10, as you reviewed last week, there are these 5 prongs of the definition of interested person. And the definition of interested person are who is allowed to appeal an act or decision at the municipal level. But it was pointed out that these definitions are used not only for appeals of permits, but also for appeals of plans and bylaws themselves. And so you may want to consider if you want to keep all of these categories for the general appeal of plans or bylaws. And so I would just say that I found this statute challenging because it is
Chris is smiling up there.
okay, good. Multiple statutes work together in Chapter 117 to create the permit appeal process. And so I was having a hard time picking where to make an amendment to make this clear. I think arguably, this whole section 4465 could be rewritten to be more clear, because a couple of the definitions under interested person reference bylaws, but we do know that they have been used for permit appeals, and so you could choose to rewrite the whole statute potentially to make it more clear, or what I have done at the bottom of page 5 is attach this other language that says, for the purpose of an appeal of an act or decision by an appropriate municipal panel, pursuant to subchapters 10 and 11, interested person shall not include subdivision 4, which is that any 20 persons. And so subchapter 10 and subchapter 11 of chapter 117, yes, there are more than 11 subchapters in chapter 117. These are the sections of law that deal with
Town plans and bylaws,
not town plans,
just bylaws.
appropriate municipal panel decisions and appeals. And so I'm open if anyone thinks that that's the wrong cross-reference, but this was my attempt to narrow it to the decisions that are coming out of the appropriate municipal panels, which would just be permit decisions and the appeals. And so that should leave the rest of the bylaw and plan appeals with access to these 5 definitions.
Got it. So
That is the intent.
got it. Anything further in what you hope to accomplish in this rewrite, and then we'll go to Thomas.
No, I think that you, in talking with you, were interested in how to have the ability of any 20 persons. Oh, and I was just in Senate Natural Resources, and Senator Baumgart's had a lot to say about this section and his work on appeals in this section, and had an interesting take that any 20 persons appealing a bylaw or a town plan had a general interest in the community's potential injury by adopting an improper bylaw. And so I think they had not seen this language I just presented. But Senate Natural was coming to a similar conclusion.
That we wanted to separate them out.
Yeah.
Yeah.
And so it was interesting because I think he has some experience with this, because I do not have any practical litigation experience with this.
Thomas.
So I like what you've done here, because my understanding is where appeals can be weaponized, not because there's actual standing, but just to delay and extend projects or when municipal permits are issued. So I feel like this thread that needle. The question I have is related to number 3 of the list. And so you are, I don't know if carve out's the right word, but you are basically saying when the appeal is related to a municipal permit, then the 20 persons doesn't apply. I wonder, I'm still concerned with number 3 in that doesn't qualify a person owning or occupying property
So
in the immediate neighborhood.
This is on page 3. This is
Page 4.
Page 4.
Number
Yep.
3 on page 4. You're carving out number 4, but it seems to me that it would make sense, consistent with what the House had contemplated, to also carve out number 3, that just because you have adjacent property doesn't mean you're agreed. And so you should have that higher bar that you have to prove agreed. Do you have any thoughts on why that's not in here, or any reflections on that point?
You do have that option. I had spoken to Senator Clarkson, who was working with the stakeholders, and just, I think part of the conversation last week highlighted of whether or not you want the location requirement. And so it's left out of this draft, but you could put it in if you like.
we could either add it here or eliminate it and have it all under agreed person. So you have to be agreed whether you're next door or not.
Yes.
So that would still allow the people next door to bylaw changes and plan changes to appeal.
Yep.
But when a municipal permit is applied, I've seen neighbors that go through the appeals process, not because they're actually agreed, but just they want to stall it out and stop the project from ever occurring without actual harm to their land. They just don't like the idea of that housing either. So that's why I would support adding 3 next to that.
And it does, we can either reinforce and add more language here or add agreed person. It has to be agreed. But it does say at the bottom of line 21, who can demonstrate physical or environmental impact. We could either
Agreed.
fully flush it out or we could take it out, as long as it doesn't impact the other abilities to appeal for biologists.
Yeah.
Right. So I'm happy to consider that.
I
I
just want to say I'm still a no on the whole thing.
Why?
Because I don't think it's a good idea to say housing takes precedence over other cases. I just think it's a good idea to listen to our judges. That's what we've always done. And any change will then create new flurries of activity with people trying to, I think, exploit a new avenue for appeal.
aggrieved persons is not an
Is it-
avenue of appeal that you think is not, I mean, I think that
Is
that
it
is,
still one person? No. No. I just wanted to make sure you know that because I don't know how much time you're spending on it, but you know.
well, I think we're spending time on it because it's appeals and I think on municipal appeals, and I think some people are very interested in considering adding this.
I'm really glad to see Chris Roy is on too, because I've been
Yeah.
wanting to hear his thoughts on this.
So let's go to John, Groveman, unless David or Randy have a thought. Let's go to John and then Chris.
Well, I like to hear, I haven't heard,
Okay,
I've gotten to
Chris.
speak on this and, I never know what Chris is gonna say,
Chris, welcome.
ever. And certainly not on this, so, yeah, but
Chris
I think it'd
Roy.
be better.
Welcome to Senate Economic Development. I'm not sure you know all of us, so we're going to introduce ourselves.
Okay, thank you.
Hi, Chris, Tom Chittenden, we met before. Good to see you.
Keisha Ram Hinsdale, same district.
Allison Clarkson, Winter District.
Randy Brock, Franklin County and Northern Grand Isle.
Good morning, Chris. Dave Weeks, Rutland County.
Nice to meet all of you. Some of you again, some of you for the first time. And thank you again for the opportunity to testify on the extraordinarily simple and clear issues that arise with respect to housing and permitting in Vermont. And I've been following this issue as it's been progressing through the committees, and I had an opportunity to review Judge Zone's testimony in particular. And I think what I'd first like to explain is how we got where we're at now and how it works, and then what the potential implications are of various approaches to changes. As you all have become painfully aware, there's sort of two concepts for appeal, standing to appeal. You have the person aggrieved standard, which currently applies to agency and Act 250 appeals, and then you have the interested person standard, which applies to zoning appeals. And I think that arose originally because of the nature of those regulatory regimes. A&R type permits, environmental permits, or Act 250 tended to be taking on broader issues that have a wider impact. And so they came up with the person aggrieved standard that talked about a particularized interest in whatever is being protected by Act 250 or the agency permit at issue. Zoning tends to be a little bit more location specific. By its nature, you're talking about dimensional limitations, setbacks, use of the building, site plan orientation. That tends to be a little tighter of a view. And so the way that they dealt with that was, or I guess you, not they, you dealt with that over the years, is that you would be an interested person in order to have standing. And interested person, as you've talked about, involves the landowner applicant, the municipality, formerly 10, now 20 people who want to appeal, or the state to the extent it's a property owner. The key provision is the third one that Senator Chittenden just referenced, and that has to do with people owning or occupying property in the immediate neighborhood who can demonstrate a physical or environmental impact on the person's interest under the criterion reviewed. So it is a slightly different standard. Now, they are different, and that's frankly made evident with Section 8504N in Title 10, and that talks about the right to intervene. So other than the right to actually file an appeal, you also have the ability to intervene in a permit proceeding and to participate, even if you're not ultimately don't have standing to appeal. And the intervention statute allows you to intervene if you're an interested person and allows you to intervene if you're a person aggrieved. So it pretty explicitly, and I think Judge Zone was referencing this, right now, person aggrieved and interested person mean different things. If you had a Venn diagram, there's overlap. Certainly, there's a lot of overlap between the two, but they're not, there's presumably some person aggrieved that isn't an interested person. So that creates the issue here. And it really then comes back to what is the goal of the committee and the legislature generally in dealing with this. One approach, which actually was just referenced a few moments ago, would really be to take a step back and come up with a cohesive, unitary set of statutes governing all permit appeals. Because right now it's a bit of a patchwork and you're trying to, connect things together and make them consistent. In an ideal world, you'd wave a magic wand and you'd have a single unitary statute that deals with party status and standing to appeal.
And Chris, we have that opportunity actually with the LURB, their work on appeals, and we have asked them to do this work both with the Act 250 appeals, but also the language we put in very specifically. It could be or more comprehend. I can't remember the exact language, but it does enable them to look at all appeals, the entire appeals process, which is part of what we were hoping would be looked at in its entirety. So they have both the option to do just Act 250 and the whole schmagaggy. So that is one option, of course, is to leave that work underscored by the need to maybe review the entire statute, to leave that and continue to leave that and underscore our interest in there looking not just at the Act 250, but at the whole statute.
No, and I think
at all appeals.
And again, if the goal is to really deal with this consistently and comprehensively, that might be because that process, the process is already established. And I've been speaking to Brooke Dingledine, who's doing the stakeholder groups with respect to the permitting issues, and I'll be participating in that. And that, frankly, may be a way to get to the final goal, which is to have a single clear set of standards for appeal standing that addresses concerns about how broad that right is, but also not inadvertently create issues that don't exist now. Because as Judge Zone mentioned, and this is what lawyers do, if you've got a category called person aggrieved and you've got a category called interested persons, and now you're saying a person aggrieved can also appeal, by definition, there's no need to do that unless it's more people are going to have a right to appeal. If you wouldn't need to add the category if it was already entirely within the interested person standard. The only reason you would add that is you're actually looking to expand it. Now, you then have the ability to sort of then come in, through the back door and sort of stitch it together in a way that person aggrieved is narrowed with respect to zoning permit appeals. But, anytime, it's the law of unintended consequences. And, anytime you start doing that, any lawyer, worth their weight is going to be sharpening up their pencils and figuring out a way to hash that out. And now you're going to talk about, a few years before those issues get resolved in the courts, so that there's some clarity. And that, I think, does run, headlong into the goal of incentivizing housing development, in particular in the short term. If you inadvertently create more uncertainty with respect to those party status and standing issues, that inadvertently may create more issues that can be appealed. One other thing about, and I will say, frankly, my experience in the recent past, so let's say over the last 5 to 7 years, is that the court has done a pretty good job of curtailing party status and keeping it relatively reasonable. One of the risks, and I deal with this all the time with clients, is let's say you've got 4 people appealing and one of them clearly you don't think that they should have, but the other 3 probably do. So you're still going to have to go through your merits hearing. You're going to have to go through the process. The risk you have of challenging the standing of that 4th person is that they have a right to appeal the denial of standing. And if that's reversed on appeal, now you got to go back and redo the whole hearing again and give them an opportunity to be heard. So it is fighting too hard on, standing and party status issues can be a double-edged sword, because if ultimately the court limits their participation, but the Supreme Court reverses, now you've lost, 2 years in the meantime, and you're back where you were before. So, applicants have to be very mindful of that. I think if a short-term approach that would address some of the concerns that Senator Chittenden mentioned and others about making sure that even if you live next door, you still have to demonstrate that impact. Now, the language in 4465B3 does say immediate neighborhood, and then it talks about a physical or environmental impact on the person's interest under their criterion reviewed. So you could tighten either immediate neighborhood, because, for instance, some recent decisions, Judge Walsh had a decision where there was somebody a half a mile away in a more rural town, couldn't see the subject property, but they might be able to hear it, and they lived on the same road, so there would be some traffic impact. So he determined that that would be the immediate neighborhood for purposes of those issues. And it's a very, as you can imagine, elastic concept. And there are some decisions where the environmental court has laid out the factors it uses to come up with immediate neighborhood. Now, maybe there's a more black and white, clear, narrower definition of that geographic scope that could be done. Or you could have language added to supplement physical or environmental impact. Lawyers can, whip out words like material and substantial and significant, or whatever language coincides with your legislative intent in looking at that. So, personally, for what it's worth, I think a more comprehensive approach, because as a lawyer too, when I file a notice of appeal on behalf of an applicant, you have to demonstrate your standing in the notice of appeal, and I got to go back every time and figure out, okay, what permit is this? What's the standard that applies? And kind of thread that needle every time. If there was a single unitary standard for standing to appeal, I think going forward, that would be sort of the ideal. And then in the interim, if you wish to address things in the near term, I think the way that opens up less opportunities to inadvertently get mired in a lot of litigation about the relationship between person aggrieved and interested person is to leave it the way it is, but tighten up the standard for interested person set forth in 4465B3, either with a geographic limitation or what degree of impact needs to be shown. And again, if you make a change to that language, the presumption that the courts make is that you did it for a reason and it's intended to change things in a certain way. And so if you added a descriptor to physical or environmental impact like substantial or significant, or if you included something more well-defined as far as how close you need to be to the project, that would be something that would be less apt to create lengthy litigation over what the meaning of the language is. But
Chris, did you see the language we sent to the House? Because we actually only reinforced and moved up the date that the LURB would do this comprehensive look at appeals.
Yep.
To go to your concern about doing a more comprehensive approach, and quite honestly, Ellen's too, we could add language in terms of our expectations of that report, that it would look at it more comprehensively and include, municipal and Act 250, because that's there now, but we could underscore it more fully. Thomas, you had it.
This is really helpful, Chris. I'm really glad you came in to testify. So you've validated concerns raised, and so I'm less supportive of this language of what I'm hearing you say, but I'm going to dangerously try to reflect what I heard the arguments for this. And what I heard Representative Mahali say is that right now in the US, if you are aggrieved, you can appeal decisions, or you can make your case in a court. Maybe not in this court, but if you are an aggrieved party, you have standing, or you can make the case for standing. And that if anything, this was just to synchronize that and to pull back or to narrow the intent to not necessarily have people that just because there's 20 of them, or just because they live in adjacent properties without being aggrieved, that they could be appealed. So if anything, this was getting a more consistent standard with having the right to take action in a court. So that seemed to make sense to me. Whether or not that narrows the realm of people that are can appeal, it seemed fair that if people are aggrieved, they should be able to appeal these decisions. They just need to prove that. So that's why I liked what was presented, but you persuaded me that maybe this is going to possibly open up a floodgate of legal challenges, making the problem worse, is what I read between the lines in your testimony. Do you have any comments on what I just put out as to why I was supportive of this language prior to your testimony?
No, and I think as an endpoint, if there was a system a statute that spoke in terms of all permit appeals, in terms of aggrieved person, and defined it in a way that was consistent with the goals of the legislature as to how broad they want that to be, I think that that's sort of the ideal way to end up. And the terminology of aggrieved person and particularized interest, that has been litigated, and that is recognized in the area of standing as an appropriate standard. And so I do agree that that's, in an ideal world, that's where you would end up. The only concern I have in the interim is in trying to do sort of a patchwork way to get there, that it creates more uncertainty and more opportunities for clever lawyers. Gosh darn, those clever lawyers are always making life miserable for everybody.
Something about that.
Going into that. But that's what would happen. I mean, I can tell you right now that I have specific lawyers in mind who are very bright and very capable, who I know would do a very fine job of making those arguments. And then the environmental court would have to address it, and there might be an appeal of it, and off we go, which is, great for my business interests, but I don't think great for the state as a whole.
Right. And if I could add, Chris, I don't know how closely you were following things last biennium. I think you testified toward the beginning of our work to our joint natural resources and economic development hearing, but we went down all of these rabbit holes to try and combine permit processes. There were challenges with adjudicating the same project in two different arenas, municipal and state. There were problems with adding another layer of appeal to a board of appeals, but not taking something else away. There were problems with who's developed the right sensibility about municipal or state versions of appeals. The true answer to all of this, without a magic wand, is to limit the ability to appeal and to create zones where there's by right development that is pre-approved. So I have no patience for going back around all of this again, unless somebody wants to do the work outside of committee, but we went down every single one of these rabbit holes, and it's why the entire appeals section got deleted from the bill last year.
Right. So to go to your recommendation, and in part, what I heard from Ellen, just as she was referencing 465, perhaps one option right now is to return and reinforce what the LURB is already doing, and asking them to expand this to look at the entire appeals process, so that we have a unitary approach and have a more comprehensive approach.
I at least think I just said I don't support that, and I would go to get that as well.
I'm so sorry. Any other thoughts? I don't know why you would stay no to that. We supported it before, and
because they have a huge charge. They have a huge charge right now, and we've asked them to come back in November already. And not gonna add things to their charge that we already looked at and determined were not a good path forward. I think that's wasting other people's time and resources and money.
I don't think it's wasting anybody's time to come up with a comprehensive approach to appeals, municipal and Act 250, and so that we can make it easier for people all the way through that system. I don't know how that.
The only way to do that is to deduplicate the appeals process.
Right, and then they could certainly do that work and begin that work.
That's
They
a
have to give
totally
them
different
longer.
set of policy considerations.
I don't think so. John.
I mean, just to
why don't
cut
you
to
talk about
the, and I talked to the LRB. I'm also going to be on this appeals group. I also talked to Bert Tingledine. It's already part of their charge. I mean,
this?
so
Exactly.
there are 4 meetings that they schedule. The first meeting is on consolidating appeals, municipal,
Thank you.
Act 250 and A&R. And so to look at the duplication issue. I think the second one is on prioritizing housing in municipal, Act 250 and A&R.
Mhm.
So they're already doing it.
Exactly.
The third meeting is on whether we should have a court or a board vis-a-vis like the housing board or some other
Right, which we
board.
talked
So
about.
that also you can't look at court versus board without considering municipal appeals because they go to the court. So that would be affected. And I asked the LRB specifically, I said, because I've heard this concern or about how to what extent the appeal study is going to look at municipal appeals. And she said, of course we are, because what I just said, because we
Right.
can't untangle.
So you think we're already going to
I
be
think-
doing
yeah.
this in the room?
I
Then
do,
I would
yeah.
support, we leave the language as it was in the bill that we sent to the House and continue to support their work in doing this. Because I think we will end up with a better product.
But can I also,
Yes,
I don't
come
get
join us and
the,
identify yourself.
I don't get the opportunity to agree with Chris very often, so.
Well, I was hoping that we were going to be able to make the
Yeah.
point at the end of
It's
this.
like
John
more
Groveman,
time.
For
John
people.
Groveman and Chris Roy are in a full agreement.
I really am. So I'm John Groveman for the record, Vermont Natural Resources Council. So I agree that it's best to do this selectively. I think I said this, we were even sort of working with the desire to do something, now. But I agree with Chris that we should have a unitary, this is kind of where this came from. We should have one
Yeah.
standard. I think part of the study group, and as this gets to what Representative Mahaly was saying, is because I think you described it perfectly, that there is, with Dick Kyle's interest in a green person, he came from US Supreme Court case law. It came from, and Chris is correct, well, for A&R appeals, there was really no standard, and through precedent, there were challenges to standing or party status. And so the old Water Resources Board kind of reached back and said, well, we're going to go with what the US Supreme Court has said is standing, which is person aggrieved, which is a specific interest. And then as I described last time, Act 250, like zoning, had these sort of oddball, if you could materially assist the commission, you could have standing. It also had, if you could show substantial harm, and it was an undefined term. And so in 2004, when we did the big permit reform that created the expanded court, it was decided, well, let's get rid of all of those in Act 250. Let's have the unitary standard with A&R and permits in Act 250. But we didn't do that for zoning. I don't remember why.
But you can still appeal multiple times. It doesn't become dispositive in A&R.
Say that again, I'm sorry.
So this is what we tried to work on. So basically, I showed everybody this earlier today before we started this. I don't know the last time any folks have seen the actual permit flow chart in the state. But unless you're collapsing any of these permits, you're not really making a huge difference.
Right, yeah, we're just talking about appeals, right? We could consolidation.
But this is, if you're appealing any of these
Yeah.
permits, you'd have to collapse duplicate permits to make a difference. To say you can appeal the same issue in municipal and then the same issue in Act 250, but you're using the same standard, that's not an intellectually valuable pursuit. Because you're still letting someone appeal the same issue both times.
Right,
So
yeah.
I don't know what you mean by unitary if we're
No,
not
unitary,
collapsing permits.
unitary in terms of who can appeal, who has standing. That's all I'm talking about, because that's.
But could they do that twice?
They're different permits, yes, they're right now.
That's the problem.
Yeah, and
No,
that's not what this language.
But that is the problem.
But that's an additional problem that needs to
That
also
is
be
the
addressed.
problem.
It is it's an additional problem because the permit duplication is one that we have tried to address in this committee. It needs to be addressed in SNRE and it needs to be addressed by the lawyer.
Well, let me give you, I mean, so this is a bigger issue, which I think, we've had so many conversations about, like, this is like a permit system issue more than like an appeals issue and so this is getting really creative. I mean, I think to address this type of problem, you could say for certain type of projects, perhaps you could collapse them into one permit somehow, right?
Yeah.
There've been,
That would be
when
great.
I was with A&R, we talked about, and this is all part of sort of the efficiency issues under what we called the lean program back then. We were like, please, even with A&R, could you have like one permit? Maybe you need a septic permit, maybe you need a water supply permit, maybe you need a stormwater permit. All those individually are permits that could be, forget about Act 250 or zoning. Within A&R, you could have multiple permits that all could get appealed. So we talked about, and this came from EPA. EPA was looking at kind of like one sort of comprehensive permit, for a
For a project.
project.
So
For
you
like,
could
yeah.
have actually a project permit, which included
Right.
all those other
Right.
categories.
Now that's not the appeal. The
No, that's-
verb is the appeal study. So,
Right.
but I do agree this is a valuable, and I think, if, we learned anything like from what's happening in our politics and the election is that whether you're conservative or liberal or Democrat or Republican, we need to think differently about these systems. And I totally agree
Yeah.
with that. But
Well, look, we all agree.
yeah, but we're focused now on this appeals. I get you a lot to do. And in that regard, I agree with Chris that the appeal study group is trying to get to, I think, a consistent standard. I don't know any lawyer I've talked to that said we shouldn't have, like, it shouldn't be different standards for appealing different permits. And then we can get your issue is a legitimate issue. Totally. It's a separate issue that deserves attention. I don't know, maybe it's a big change though. It's a big, you really have to grind through how that would work and.
So they're tackling one big thing.
Right, they're tackling.
And we
the
are
big thing,
all waiting and very curious and interested in what you and they come up with. And maybe we attack the duplication. Absolutely.
So I heard Mark, I've talked with Representative Mahaly about this, this came up in the House. And we talked about maybe using the tier 1 map. So we know that that's an area where we want to develop. Maybe we could have that sort of expedited kind of one permit,
Not maybe, but you should.
Right. Well,
You
we
are
have to-
exempt.
right.
You
So-
are exempt from appeal.
Right. So once we have those maps and kind of see what we'll have by next session, we could kind of take a look at that and look at how to expedite permitting. I agree with
There's
you.
no land use question.
The question is really on the front end, not on the back end, right? Appeals is the back end, right? The front end is what permits do you need and
that's the time challenge.
And as long as you have creative lawyers and you have multiple appeals processes you can exploit, you will. And we could change this with duplication and dispositive permitting, saying that once a matter has been appealed and decided upon, it is not grounds for further appeal.
right. But I do think
That's
it needs
the
to be
A&R.
it's the same principle as it's the litigation base. It's not, there is another side of this coin. There is development in areas where, it's not, there are natural resources impacts, there are property impacts, and that's when that's when people, I'm dealing with this with the right departments.
Those each have a specific permit. They shouldn't be multiple bites at the apple.
Well, it depends upon where it is and what the issues are. That's why I said I think we should look at the map, but this is the policy debate that
Right.
we need. I think that having the maps and understanding, what we did last year, we said, okay, we need to identify these growth areas. We already said within those areas, actually 50 exemptions will apply. I think we should look at how A&R permitting works in those areas.
And that's
as well.
my bill in natural resources, so I'll probably see you at 9 a.m.
Yeah, I mean, I think there's different ways to go about it. But that's it's an important topic, it's a different topic. It needs a lot of analysis to be done right? We want to do it right. So
I guess we would ask you at this point, would you support our language that went to the House and simply continue to trust the work of the LURB in conjunction with their stakeholders, and hopefully we will have something to work with for next session.
I mean, yes,
I'm not sure what language we're referring to.
right. I do support that. I do. feel like, you know what, we did spend time in the House. I know that Representative Mahaly feels strongly if that, you know, for the reasons that you stated, that the change would bring consistency and it would be helpful. The one thing I disagree with Chris on slightly is I think because the person degree standard is so embedded, I don't see it creating like a floodgate of like new legal issues, but I mean, I guess, you know, lawyers could debate whether that's true or not. I don't think Representative Mahaly thought that, which is why, you know, you know.
Did he hear from
proposed-
Judge Sone?
Oh, yes, yep. I heard from Judge, yes, he did, yeah.
Yep.
When we discussed, Zoe's testimony and so on. So, but, you know, I think if you do take it out of the conversation, we'll continue. I think the House feels strongly about trying to maintain that, but that's something between the Senate and the House.
They should. This is the first year they've talked about permitting and appeals. They were not, I mean, you know this,
Yeah.
last year it was all natural resources, so
Right, I was
committee
that
needs to
committee,
do
right.
some
Yeah.
full education.
Yeah.
Before they pick something up like that.
Yeah, but I think ultimately, and I think, you know, yes, I think that you're gonna get recommended, you're gonna have people like Chris, you're gonna have people like me, you're gonna have lots of other types of people with, you know, if we could come together and look at Venn diagrams and see, you know, with regard to appeals, you know, things that we could do to make the system more
Right, and
efficient.
And you're working with
Yeah.
the LORB as they do this work to make these recommendations.
I
And
think
that I support.
there'll be a good
particularly after-
series of vetted recommendations that choices will have to be made. But at least, you know, you'll have, I think, you know, a fuller picture of what those choices are and where people stand on them.
And if we moved on changing this at the moment, the agreed person said, and so we might change it, so it would be in law for 6 months before we then, or maybe a full year, before we then do a more comprehensive
Yeah,
appeal.
possible, yeah.
Or, I mean, it
That's
just,
certainly possible.
it seems to
Yeah.
much wiser to wait and do the more comprehensive approach, which we already are doing. So I guess, anyway, what committee members, what do you think?
I did like the idea that Chris suggested if we don't do what the House suggested, but instead added material substantial or significant to number 3. I don't know what the implications or what testimony there would be on that. If Mr. Shoup had any thoughts.
Groveman,
Favorite Grover.
I'm not as wealthy or retired as Mr. Shoup. It's quite sad, but that's my problem. You
But
know
we're
what?
glad you're still here.
Thank you, I appreciate it.
Was he your predecessor?
No,
He
was employed.
yeah, I'm not the director. Lauren Hurl is the director of the university, but I worked with Brian, but we're all bearded guys.
Mr. Groveman, my apologies.
That's okay. No offense to him. Not by far the worst thing that's been said to me.
So so Thomas, what you're suggesting is amending current law that we passed last year, amending current law to add in section 3
So on the document that Ellen handed out on page 3, sorry.
or page 5.
No, I'm sorry, page 4, number 3.
Yeah,
Yes.
bottom of,
Interested person definition, a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter who can demonstrate a physical or environmental impact. I believe I heard Mr. Roy suggest if that were to be a material or substantial physical or environmental impact, that might address, and I'm guessing this is based on your professional experience with appeals, Mr. Roy, and understanding a little bit about what the legislature is interested in doing is narrowing or reducing the amount of NIMBY appeals or lawsuits, the frivolous appeal that are just meant to delay and to install to stop housing from occurring. Adding material or substantial or significant to physical or environmental impact seems to make sense to me from my lived experience in South Burlington.
Well, and I've also, you know, had the pleasure of wearing a bunch of hats. I was on the old environmental board, so I addressed things from that perspective. I was on the Wilson Select Board for years. I was on the Burlington Planning Commission in the far distant past. So I've dealt with these issues. The trick, and if it was easy, it would have been fixed a long time ago, is how to allow people with good faith, legitimate concerns about development to be heard while not allowing people with less noble goals in mind to abuse the process to their ends. And if that was an easy standard to come up with, it would have been done a long time ago. But that's the trick. How do you make sure people with legitimate concerns have a right to be heard while preventing people from abusing the process for the purposes of delay and creating a war of attrition in the hope that you'll grind the project to a halt.
Right.
Right. So, I mean, I guess I would say if the spirit is not to make changes until we get the broad recognition that we don't make changes, I would be more comfortable with that if you've had a person agreed and standing in there, because then,
I think
you know,
if we're gonna do that, then we probably have to accept the yes, I agree with you,
I
John.
think that's what Representative Mahaly would say. You would say, well, we want to make sure that that's the floor, that's constitutional standing, like Chris is saying, that, and that's designed to make sure that people who have legitimate concerns have to be processed, you know, and have the right to be heard. So, you know, so.
So we can also think about this over the weekend. We're gonna try and start landing the housing bill next Tuesday. We're gonna start walking through and checking it off, what we're okay with, what we're not, and so that we can get this back to the House. But I think we're.
That I'm looking at, based on the discussion here and not being intimately involved in doing this on the ground as the two of you are. I asked, first of all, if I divide the state in half and try your system and the other system, you know, for a few years, and then count the number of projects that have been appealed and delayed, but we can't do that. I have just a few tests about whatever we do, and the tests are things like, is it more or less costly? Is it faster or does it take longer? Is it less labor intensive or more labor intensive? Does it require more litigation or less litigation? And of whatever we come up with, those are the kinds of tests, at least that I would apply to what we're talking about.
So Judge Zone, I think, would answer those questions, if I recall correctly, that it would create more uncertainty for the courts to have to work through and would possibly add length. So I would rest on Judge Zone's and Chris Roy's to now I no longer really support what the House brought forward because he did address some of your concerns.
Right. And
You also asked the whole issue of time, because we talk about money, we're really talking about time in a lot of these cases. And when people want to delay things, they are able to delay things because we have so many steps to go through. The whole issue of municipal zoning and municipal rules and permitting versus the Act of 50, a lot of that is very, very duplicative, at least what I see. And
I
how
think
can we
that's
deal with that? And that's a longer term issue to deal with.
I think that's an SNRE issue that I hope might be explored in Keisha's bill that Tom and I are on, but that she's bringing forward tomorrow morning. Because I think if we could do the same thing we're asking the LRB to do on appeals, in some ways the same thing has to happen at ANR with the LCT and the LRB to consolidate permits in some thoughtful way or look at that. And so maybe we can be.
Yeah, there are obviously some systems issues. There is systems issues regarding how particular agencies, and ANR is one that I target a lot of just taking forever to do something and not being responsive to the public. Those are other issues.
Totally. I mean, that's what we're saying. Those systems that again, I harken back, everything old is new again. I was ANR general counsel 10 years ago or something like that.
A while.
And
I remember
Commissioner Beers, we had all this lean work we took from industry that basically just what you said, we went and had meetings with all the different programs and systems. How do we eliminate steps? Where's there overlap between the permit programs? Where could we have consolidation? Some good work came out of that. Some changes came out of it. We need to go back to that. There's a lot of good information there. Looking what's happening with the federal government now, that's what I just described, and your concern is the right way to do it. Just going in with a sledgehammer and just banging down makes things worse, because you'll hear from consultants that Chris works with, like right now under the system, they need to get permits. So if you get rid of the people and you don't make the systemic changes, you're just hampering this program and you're slowing things down and you're making things worse,
and creating chaos, which we're not supportive of. David, any thoughts?
No, I'm listening. This is a new topic.
Yeah, no, and it's a complicated topic. I think, and Thomas, what are your?
No, I just wanted to concur that as much as I've reflected that this has already been hashed over, it's new to me diving deep into these things. So I've appreciated the testimony and discussion.
Yeah, it's part of what makes this job so interesting is learning all the time.
And I think I'm excited about, I think one of the positive things that can come out of what's happening in our country right now is like, we need to think creatively and differently about how to do things. As someone who works for an environmental group, we just had Earth Day celebrating the environmental laws that were created in the 1970s that Richard Nixon was
Yeah.
president and he shepherded.
EPA.
Those are great laws and they're bedrock laws, but we really like, they're 60, plus years old. And so how they get implemented, of course, we need to look at that. We can't just say we need to just do things the way that we've always done them. But you got to be careful, just like Chris is saying on it does. You pull one strand.
So to
Yeah.
that end, I would like to have us seriously think about supporting the language we sent to the House, supporting the work of the LURB, making sure John and Chris and others are testifying with the LURB and have the opportunity to do that. So that we can end up where we're hoping, which is really a unified, comprehensive review of appeals and a recommendation for how to go forward. And I think Ellen first mentioning it with doing that with 44, that we should do that with 4465. That was very helpful. So I'm very glad we did our work in support of Flor's work, and just we need that work a little sooner than, if we can, and if they have to extend it, we're open to their extending it, but I think want to act on this next session.
No, I understand. No, they understand.
Yeah.
They're getting going. We're starting
Yeah.
to meet.
So Chris, I hope you engage with them as well.
Yes, no, and it starts, I think the first session's on May 5, so they're diving right in.
Yeah.
More
Right.
than we have now.
So, we will land on this again on Tuesday. I would urge us all to sort of figure out what you want to do. And
Great testimony,
Thank
Mr.
you.
Groban.
thank
Thank
you,
you,
Chris.
Senator.
Lovely to meet you. Maybe we've met before. Anyway, good to have you. Thank you, John. Thank you.